Good day to you all, and I bring warm greetings from Trinidad and Tobago, warm sunny greetings. Our carnival season is upon us, so warm festive sunny greetings from Trinidad and Tobago. I bring you greetings from the controller of the Intellectual Property Office as well, Mr. Regan Asghar Ali. And I have the pleasure of just a few minutes of your time to talk about the opposition processes and procedures from the Trinbagonian perspective, the Trinidad and Tobago perspective. Today, I'm doing a dual presentation with Ms. Shamila Jacob here. She's on screen, and she is one of our best kept secrets in not just in Trinidad and Tobago, but in the Caribbean. She is an expert, especially at trademark procedures, amongst other things. And so now I will hand you over to Ms. Jacob, and she will begin the presentation.
Hi, good morning again. So let's take a look at the practices of the TTIPO in opposition procedures. Okay, so this morning we're going to look at the introduction, opposition procedure, adjudication, inter partes hearing, the role of the hearing officer, and judgments. So just to recap, what is a trademark? A trademark is any sign capable of being represented graphically and which is capable of distinguishing goods and services. When does an opposition arise? When the trademark has been examined, the mark is either accepted or refused. And again, I should reiterate that trademarks are both examined at both the absolute and relative grounds. And most of our refusals are based on the relative grounds. So as we go further into the presentation, you'll see the limited amount of oppositions that we have had at the TTIPO. And this is based on the examination procedures, right, Kavish? If accepted, it is then published in the online journal where the mark is now available for the public to inspect. Any person may file an opposition. We might ask ourselves who may oppose. It could be any person may file an opposition. A person may, within the prescribed time from the date of the publication of the application, give notice to the controller of opposition to the registration. There are also other type of oppositions, that is applications to alter a registered trademark, revocation for non-use, which under our old law was termed rectification actions. Opposition files. An opposition file numbered sequentially in a series preferred prefix OPP should be open. What we do at the TTIPO, which is followed from the UK practice, is that as soon as an opposition is filed, we open a file, we issue a trademark number, and we always prefix it with the words OPP or REC for rectification revocation action. So the opposition number should be entered prominently on the minute sheet of the application being opposed, and the file for the application should be kept together with the opposition file. So in our opposition practice, what we will have is a home file and an opposition file that is always kept together for the duration of the opposition period. Opposition files. All formal notices, correspondence, and evidence relating to the opposition should be filed in the opposition file and also entered on IPAS. Right, so let's take a look at the checklist. Now, this checklist was designed to ensure compliance with trademark law and with the legislation, that is. It's carefully monitored using the checklist by the team. It may seem a bit long, but if you, can we want to explain the checklist a little bit?
Absolutely no problem.
Okay,
in terms of the checklist, we go through every single document and we make sure that it's properly filed. We look at the date of filing. We look at whether extensions of time are given. We talk about the specific rules that guide the filing of documents. So in the entire procedure, it goes step 1, step 2, step 3. You'll see, we'll do a visual slide very shortly, but you can see every single step is clearly mapped out. And we find that this helps at least our processes significantly, because opposition procedures can really get lost in translation if you are not upon it at all times, especially when the parties are requesting extensions of time to file extensions of time to file documents, and there are multiple extensions, and we have negotiations between the parties, and we need updates on those negotiations. So that's from our perspective. So we have the various rules there, whether consents are given for extensions, for example. That's another point I will touch on shortly.
Right. So just to add, it chronicles the dates that documents were filed. It indicates whether consent was filed for extension of time. It also identifies the regulation that are applicable to the different stages. And I think that's basically it. It's checked constantly, monitored by the team. We have an opposition team that would constantly be on this checklist. So this is the entire checklist, the scale of costs that we'll discuss a little bit further. So let's look at the opposition procedure. So this is the procedure we follow at the TTIPO. It all starts with the publication of the trademark. When the mark is published, it gives rise, it's open for 3 months, wherein which anyone can file the notice of opposition. It then goes to counter statement, statutory declaration by the opponent, statutory declaration by the applicant, statutory declaration in reply. You can also file further evidence with the leave of the controller. And then there's skeleton arguments by the applicant, skeleton applicant arguments by the opponent, and then the hearing. So the notice of opposition. A notice of opposition can be filed within 3 months from the date of the publication. There are no extension of time to be granted for filing of the notice of opposition. It is filed on our Form 6, and a fee of $1,400 must be paid. The notice of opposition must include the grounds on which the opposition is based, such as the mark is devoid of any distinctive character or the relative grounds for refusal of registration. Counter statement. Within 2 months of receiving the notice of opposition, the applicant, the party who applied for the mark, has to file a counter statement. If no counter statement is filed within the time, the application is deemed to have been abandoned. However, parties can file for an extension of time. Filing of evidence. The opponent must file statutory declaration supporting the opposition. Must be filed within 2 months of the receipt of counter statement. If not, the opposition deemed withdrawn. Extension of time permissible at this point of filing. The applicant must file their statutory declaration, which must be filed within 4 months of the receipt of the opponent's statutory declaration. If not filed, application deemed withdrawn, but at this point as well, they can apply to the office for an extension of time. Opponent to file statutory declaration strictly in reply to the applicant's declaration. The order of presenting evidence. Evidence is first filed by the opponent, which we call our evidence in chief. The second piece of evidence is by the applicant, and then the final piece is the opponent in reply. At this point, I'll just hand over back to Mr. Sitahal. Continue with the ADR services.
Thank you, Ms. Jacob. And while we don't have a statutorily enshrined cooling off period, we do encourage ADR, we do encourage alternative dispute resolution between the parties, and it has been used. We have an agreement, a memorandum of understanding between our office and country and WIPO's Arbitration and Mediation Center. We have negotiated some very, very cheap rates, some of the cheapest in the world, to access the mediators and arbitrators, experts from around the world. There are 5 appointed experts from Trinidad and Tobago who can also be accessed in that group of thousands of mediators. So, and it's often encouraged, especially prior to skeleton arguments being filed. We want to ensure that we don't go forward to a hearing necessarily that is in a situation where the parties want to resolve the matter. So we encourage it from the onset of the opposition and the counter statement being filed. In terms of our skeleton arguments, if we're going forward to a hearing, skeleton arguments are required to be filed prior to the hearing, and they usually include case law, points of law, but they cannot include fresh evidence. Fresh evidence must be done with the discretion of the controller, and application needs to be made to the office to include any fresh evidence, and grounds must be given as to why it was not included in the first place when evidence was being given. Now, we have written into our law, into our trademark regulations, the opportunity for parties to have the hearing via written submissions. This is an option that we have found very useful, and all of our oppositions, I would say, close to almost the last 7 years, 5 to 7 years, have all been written submissions. So parties really, they don't want to come in for oral hearings, especially in light of COVID and what happened in the pandemic. They don't want to actually come in for an oral hearing. So parties agree, both parties have to agree in writing via letter to us that they are willing to go forward by written submissions. And then we go forward on that basis for both parties to file. One files and then the other does. The burden of proof is always on the applicant, according to our jurisprudence, and that's jurisprudence from the UK, that the applicant has the burden to prove that their mark is registrable. If they choose the oral hearing, which hasn't happened in a long time, but if they choose the oral hearing, we consult with the parties about a convenient day and time, and they have to file their relevant forms, and they confirm their attendance, and they come in and they have their arguments, and lawyers be lawyers and stand on occasion. In terms of extensions of time, and I thought this was important for us to raise, we're finding it more often that we are interim proceedings, we find ourselves in interim proceedings for extensions of time. So where a party requires an extension of time, usually they go and get the consent of the other side. However, if consent is not granted, it goes to interim proceedings. And it is a trial within the trial. It actually requires the filing of submissions and law and require a hearing. If the controller decides that he wants to dispense with the hearing, it can be done on the specific basis of the circumstances. We have released judgments on extensions of time, one fairly recently, where it was an extension of time for written submissions. And because it was written submissions, it did not involve evidence, and therefore the extension of time was granted. It was a second extension, if I'm not mistaken. And so it was an important matter for me to bring up that extensions of time are sometimes very difficult to deal with. In terms of a hearing officer for the matter, it can be the controller, the deputy controller, myself, or a legal officer, to where appointed by the controller. And the role of the hearing officer is to listen to the submissions and all the preliminary matters and guide the parties on the issues, looking at all the evidence that is presented during the hearing. Judgment is done within a 3-month period, and at the end of the hearing, we'll set a date for judgment to be given. If parties ask for costs in their written submissions, we have our scale of costs that you would have seen. All judgments can be appealed to the High Court based on an error of fact on application of law. We find that we don't get many appeals. There have been appeals. Appeals have gone to the Privy Council, straight to the Privy Council. So High Court, Court of Appeal, Privy Council, as is the process in Trinidad and Tobago. Right, so Shamala, I'll just hand back over to you to finish up the presentation.
Okay, looking at how much opposition and rectification removal matters we have at the office. Presently, we have 12 matters before the TTIPO. We have 1 rectification matter. We have 2 opposition matters. And for 2022, we just received 2 rectification matters. Right. This is the 3rd schedule of the scale, of course. This is what we use to determine, well, based on the outcome of the notice, the decision, right? Based on the judgment that is delivered, we use this to determine the cost that's awarded to the to each party. Again, important points to note: proper and efficient record keeping. We use iPass, we use the diary, we use a checklist. What the diary is that we have a step-by-step detail. We issue the number, the parties, so it's easily accessible. You could pull the diary, you could see the status of the application, at what point it is, what is outstanding. Then we have like a double opposition where parties oppose one another. We had this case where this party opposed the other, and then the opposing party came and filed a notice of opposition against the first party. Then we had multiple opposition to one trademark. In this matter, we had opponents filing against one another. And then we had a third party who asked to intervene in the proceeding by filing an action against it. Then there's also the possibility of a win-win judgment where both applications are registered. The role of the IP library. In 2007, the IPO was granted depository library status by WIPO. As such, WIPO will provide the IPO with annual publication, including books, magazines, CDs, and reports on various topics. So once again, thank you for